Hello, welcome back to class. Okay, just now we had about 10 minutes break. Okay, so I think that you again feel fresh and then become ready for following the lecture. Okay, the remaining part of the lecture will be uh, concerned with persons who are entitled by law to avoid a voidable jurisdiction act. Okay, when a jurisdiction act is voidable, it does not mean that anyone can just exercise the right to avoid the jurisdiction in question. Okay, this is because the law specifies persons who are entitled to avoid uh, the jurisdiction act which is voidable. Okay, so the persons who are specified by law, okay, there are the persons mentioned in section 175. Okay, we are going to look at the persons, according to section 175. Okay, if you look at section 175, okay, 175 just provides as follows. A voidable act may be avoided by, okay, one, two, three, four. Okay, so what is seen in 175 are what is seen in section 175 are persons who are entitled by law to avoid a voidable jurisdiction act. When a jurisdiction act is voidable, okay, on the ground of say the fraud, duress, okay, or even the lack of capacity, okay, on whatever ground, okay, so it does not mean that anyone can just avoid the jurisdiction in question. Okay, if you want to avoid the jurisdiction in question, okay, you will have to make sure that you are the persons who is allowed by law, okay, indeed by section 175. Okay, 175 just specifies different cases. Okay, each case, in each case, there will be different persons who are allowed or permitted by law to avoid the jurisdiction in question. Okay, so we are going to go through section 175 right now, but I'm not going to read, okay, the whole thing here. Okay, we are going to go each paragraph. Okay, in paragraph one, subsection 1, 2, 3, 4. Okay, so we are going to deal with is subsection. Okay, beginning with the first case in subsection 1. Okay, in subsection 1, section 175, in its subsection 1 provides as follows. Okay, we are going to read the wording here. Okay, a voidable act may be avoided by one, legal representatives or a minor who becomes sui juris, provided that a minor may make avoidance before he becomes sui juris if consent to has been given by legal representatives. Okay, so we can see that what is addressed in subsection here. Okay, it is the case of what? It is a case of a voidable act, which involves a minor. This means that, okay, a jurisdiction act becomes voidable because of the age. We have seen that that when a minor makes a jurisdiction act, okay, a minor needs to get consent from the minor's legal representatives. Of course, in most cases, the legal representatives of the minors are, the minor's own parents. Okay, so that if a minor just has entered into a jurisdiction without obtaining consent from his own parents, that means that jurisdiction will become voidable. So when the jurisdiction which has been made by minor becomes voidable, then who are the persons permitted by law to avoid the jurisdiction? Okay, that is the case in the section 175 subsection 1 here. Okay, so we can see that from this subsection 1, okay, the two persons are allowed by law to avoid the jurisdiction which becomes voidable on the ground that it has been made by a minor without consent from the legal representatives. Okay, the first person, okay, who is allowed by law to avoid the jurisdiction is the legal representative. again, I mean, in most cases, the legal representative of the minor, uh, who who is the legal representatives of the minor? The parents, of course. Okay, so the mother and father. Okay, so that's why, okay, I try to put an S here. Okay, legal representatives, simply because in most cases, okay, the parents, both father and mother, okay, they are the legal representatives of the minor, so that the parents, as the legal representatives of the minor, are entitled by law, okay, by section 175, subsection 1, to avoid the Juristic Act, which becomes voidable, okay. We have to just note one thing. Sorry for this, okay. I'm going to just take some water. Now it's very hot in Thailand, okay. It's summer, okay, now, so that we get thirsty very, very easily, okay. So let me just have a drink, okay. So thank you very much. Now back to this one, okay. According to section 175, subsection 1, okay, the two persons are entitled by law to avoid the Juristic Act, which is voidable, okay. The first person is, I mean, the legal representatives, okay. So we have to note one thing, okay. The legal representatives can avoid the Juristic Act, which is voidable, only before the minor becomes sui juris. Why so? Because we have to recall that the legal representatives, okay, that can just exercise the what? The parental power over the minor only when the minor remains the minor, okay? If the minor ceases to become the minor has attained the age of, let's say, 20, or the minor is legally married, in that case, the minor will become sui juris, okay? Once the minor becomes sui juris, then the parents or the legal representatives no longer have any parental power. Okay, so that if the minor to attain the age of 20 or becomes legally married, the minor just ceases to become a minor. The minor will be sui juris from then on. The minor can do everything in his own name. Okay, so that we don't require any legal representatives to do things on behalf of the minor anymore. Okay, so once the minor ceases to become the minor, once the minor has become sui juris, then the legal representative cannot just avoid the Juristic Act, which is voidable. Okay, it is the minor himself or herself that is going to exercise the right to avoid the juristic in question. Okay, so this is something which we have to put a note on. Okay, so now moving on to the second person who is entitled by law to avoid the juristic act, which becomes voidable. Okay, the second person is the minor, of course, right? So the minor, of course, I mean the minor can just exercise the right to avoid the juristic act. Okay, after he is sui juris, because when he becomes sui juris, okay, he just has his full capacity, so that he can just exercise the right to avoid the juristic act in his own volition. Okay, but if he is not yet sui juris, okay, before becoming sui juris, the minor is also allowed by law to avoid the juristic in question. Okay, but in this case, if the minor has not yet, okay, become sui juris, then the minor can just avoid the juristic act only upon consent of the legal representative. Okay, if you look at the wording in the section 175, subsection 1 again, okay, a voidable act may be avoided by, the subsection 1, legal representatives or a minor who becomes sui juris. So, the minor can avoid the juristic act when he becomes sui juris, okay, provided that a minor may make avoidance before he becomes sui juris if consent thereto has been given by legal representatives. So that's mean that, okay, if the minor elects to avoid the juristic act in question, okay, before he becomes sui juris, he needs to get consent from his legal representatives. Okay, so this is the case of a minor. Now we are moving on to the subsection 2. Okay, subsection 2 of section 175. This subsection is dedicated to addressing what? Addressing the case of what? The case of in committing person. Okay, in committing person. Okay, you have to remember that and in committed person, it is the person who is what? Who is of unsound mind, and that person is judged by the court as an incompetent person. Okay, because his mind is unsound, he does not know anything. Okay, he will not be able to do things by himself, so that he is placed under care of whom? Under care of his guardian. Okay, so we have to just recall that the minor is the person who is of unsound mind and judged by law as an incompetent person. Okay, so that when his mind is unsound, it is impossible that he can just avoid the juristic act by himself. Okay, so that must be done by the guardian. As long as the incompetent person remains incompetent. Okay, so that he cannot avoid the juristic act by himself. It is his guardian who does so for him. Okay, so if we look at what is said in section 175 subsection 2. Okay, a voidable act may be avoided by the person judged by the court as an incompetent person. Okay, in fact, subsection 2 addresses to the persons. Okay, and in competent person and also a quasi incompetent person. Okay, but for the ease of convenience of our explanation, okay, we are going to split into two cases. The case concerning the case concerning and incompetent person. Okay, and a case concerning a quasi incompetent person. Okay, so now we are going to just talk about the case involving an incompetent person. Okay, so given that subsection 2 addresses two cases, okay, I'm going to read the provision of section 175 subsection 2 only in the light of an incompetent person. Okay, so what I'm going to read, it is the one which I underline. Okay, so the wording which is underlined here, it is directed at and incompetent person. Okay, so the other parts will now be omitted. Okay, other parts which is concerned with a quasi incompetent person is omitted for our purpose now. Okay, so I'm going to read only the words which is concerned with the case of an incompetent person. Okay, so look at the wording here. Again, a voidable act may be avoided by the person judged by the court as an incompetent person. Okay, when such person ceases to be an incompetent person. Okay, or the guardians. Says if you read the one which I if the one which I put in the underlined format, we can see that there are two persons who are permitted by law to avoid the Voidable Juristic Act in the case of an incompetent person. Okay, the first one, of course, is the guardian. Because what? Because you have to be mindful that an incompetent person, okay, cannot do things by himself simply because his mind remains what? His mind is unsound. So when his mind is unsound, he cannot do anything by himself. So it is the guardian who who does everything for the incompetent person. Okay, so that it is obvious that the guardian can just exercise the right to avoid the Juristic Act, which is voidable. Okay, but one thing again to be noted on this point. Okay, the guardian may exercise the right to avoid the Juristic Act. Okay, In the case of an incomplete present, only when what? Only the avoidance is made before the incomplete present, okay, recovers capacity, because the guardian can have the power. The guardian can have the power over the incomplete present only when the incomplete present remains incompetent. Okay, but if the incomplete present ceases to be an incomplete present, okay, by what? By the revocation, by the order of the court revoking, the order adjusting that person as an incomplete person, okay? If there is the court order revoking the order adjusting that person as an incomplete person, okay? That incomplete person ceases to become an incomplete person, and then from then on, that incomplete person will regain what? Will regain his capacity. So when he resumes capacity, then the guardian will no longer have any power over the formerly incompetent person. Okay, so once the incompetent person regains his full capacity, then the guardian is in no position, okay, to exercise any right to avoid the jurisdiction anymore. It is the incompetent person himself, okay, who will just what? It is the former incompetent person himself who can just exercise the right to avoid the jurisdiction. Okay, so back to the case of the guardian. Remember, the guardian can just exercise the right to avoid the jurisdiction, which has been made by a person of unsound mind only when the incompetent person has not yet, okay, regain his capacity, okay, only before the incompetent person recovers capacity. Okay, so that is one thing which you have to be careful about. Okay, so now moving on to the second person. The second person who is entitled by law to avoid the jurisdiction is the incompetent person himself. Okay, but you have to just be mindful that the incompetent person can just avoid the jurisdiction only what? Only after he ceases to be an incompetent person. Okay, that means that only when the court has made what? Only when the court has issued the order revoking the order adjusting him as an incompetent person. Okay, so when the court issues an order revoking the formal order adjusting him as an incompetent person, then from then on he will cease to be an incompetent person, so that he will just have his own capacities. Okay, so we have to realize that, okay, before the incompetent person regains his capacity, he is in no position to avoid, okay, the jurisdiction, because his mind is still unsound. When his mind remains unsound, it's impossible that he can just make any decision, okay, to avoid the jurisdiction. The law does not allow him to do anything, so that before he recover his capacity, he cannot, okay, avoid the jurisdiction, which becomes voidable. Okay, so again, there are two persons, okay, allowed by law to avoid the jurisdiction in the case of an incompetent person. Okay, the first one is the guardian. The guardian can just avoid the jurisdiction only before the incompetent person regains his capacity. Okay, so, but in the case where the incompetent person wants to avoid the jurisdiction, okay, he will have to do so after he ceases to become an incompetent person. Okay, before he regains his capacity, okay, his mind remains unsound, so he is not in the position to avoid the jurisdiction. Okay, so this is the case involving an incompetent person. Okay, now moving on to the case of a quasi incompetent person, we have to recall that, okay, a person can be adjudged as a quasi-incompetent person when he is not able to manage his own affairs. His mind is still sound, not unsound, okay? His mind remains sound, but the thing is that he is not able to manage his own affairs, maybe because of his intoxication, maybe because his prodigality, okay, habitual prodigality, or I mean the cause of the same nature, so that, you know, in this case the law does not allow him to enter into certain juristic acts, not all juristic acts, okay? So let's suppose that a quasi-incompetent person, okay, a quasi-incompetent person has made a juristic act. In that case, if he has made a juristic act without consent of him, without consent of the person who takes care of him, the law call this person as curator. If a quasi-incompetent person has entered into, you know, a juristic act specified by law, okay, the specified by law as important, so that, you know, that we have to be mindful that, okay, a quasi-incompetent person is not allowed by law to enter into certain important juristic acts. Let's suppose that, okay, a quasi-incompetent person has entered into one of those important juristic acts. The consequence is that juristic act will be what? That juristic act will become voidable, so that it can be avoided. The law say that, well, it can be avoided by whom? We have to look at, you know, the section 175 subsection 2 here. Okay, I'm going to just read the part which is concerned with a quasi-incompetent person, okay? A voidable act may be avoided by, okay, the person adjudged by the court as a quasi-incompetent person when such person ceases to be, okay, a quasi-incompetent person, okay, or the curator, okay, provided that a quasi-incompetent person may make avoidance before he ceases to be a quasi-incompetent person if consent thereto has been given by the curator. So what does it mean here? From these provisions of section 175, okay, in relation to a quasi, section 175 subsection 2, in relation to a quasi-incompetent person, okay, we can see that there are, again, two persons who are permitted by law to make avoidance. The first one is the one who takes care of him. You know, the person who takes care of a quasi-incompetent person is what? Is a curator. So in this case, the curator, it is one of the persons allowed by law to avoid the juristic act, okay? But again, one thing needs to be noted. This is the same as the case of an incompetent person, okay? The curator has the power over the quasi-incompetent person only when that quasi-incompetent person remains the quasi-incompetent person, okay? But if a quasi-incompetent person ceases to be a quasi-incompetent person, then the curator, you know, will not have any power over the quasi-incompetent person anymore. Okay, so if the curator wants to avoid the juristic act, okay, then he needs to do so just before the quasi-incompetent person recovers capacity. Okay, if the quasi-incompetent person recovers his capacity, okay, then the curator does not have any power over that quasi-incompetent person anymore. Okay, so this is something to be made clear. Okay, so you have to be mindful that, okay, if the curator wants to avoid the juristic act, which is voidable, then the curator will have to do so before the quasi-incompetent persons, okay, the ceases to be an incompetent person, okay. Now, how about the quasi incompetent person himself? Okay, when a juristic act is voidable on the ground involving a quasi incompetent person. Okay, the quasi incompetent person, sorry, a quasi incompetent person may exercise the right to avoid that juristic act. Okay, but he will have to do so. Okay, there are two stages of time. If he ceases to be a quasi-incompetent person, that means that means that he has his full capacity, so that he can avoid the juristic act. Okay, he can avoid juristic act in his own name without any consent, of the curator anymore. Okay, but if he wants to avoid the juristic act before he recover his capacity, before he ceases to become a quasi-incompetent person, okay, then the law requires him to obtain consent from the curator. Okay, I mean, it is the same thing as he makes a juristic act, which is important. Okay, it is the same thing as the situation when he wants to make a certain juristic acts of particular importance, whereby the law requires him to obtain consent from his curator. So if the quasi-incompetent person wants to avoid the juristic act, okay, before he recover his capacity, he has to do so, okay, upon consent of his curator only. Okay, so that is something to be made clear. Now, what about what about other cases? Other cases are the case which are concerned with the mistake, fraud, duress, or the person or a person of defective unsound mind. Okay, so now we are going to move on to consider the persons under the subsection 3 and subsection 4 of section 175. 175 subsection 3 deal with the person who has declared an intention on account of a mistake, fraud, or duress. We can see that a juristic act may become voidable on the ground of mistake. Remember, the mistake as to what? The mistake as to the quality of the person, or the mistake as to the quality of the property. Okay, will also make a juristic act voidable. Okay, so there is also possibility that juristic act becomes voidable on the ground of mistake. So when a juristic act is voidable on the ground of mistake or fraud or duress, who is the person allowed by law to just avoid the juristic act? The answer is found in section 175 subsection 3. The person who is permitted by law to avoid the juristic act is the person who has declared an intention on account of mistake, fraud, or duress. Okay, so if you, let's suppose that you just mean that you have made a contract for a sale of your house to the other party. You are A, the other one is B. Okay, A has made a contract for a sale of a house to B. Okay, and that sale is procured, let's say, by fraud. In this case, this contract of sale becomes voidable. So if you do not want to sell anymore, if you do not want to be bound by this contract anymore, you will have to avoid this contract. Okay, so if you want to avoid this contract, you are the one who has declared an intention on the ground of fraud. Okay, oh sorry, just now duress, right? Fraud and duress mean the same thing. Okay, if you have sold your house to the other one on the ground of fraud or duress, okay, then you can avoid the contract because you are the person who has declared an intention on account of fraud or duress according to section 175 subsection 3. Okay, so this is something very straightforward. Okay, now how about when Section 175, subsection 4. Section 175, subsection 4 deal with the person of unsound mind. Okay, the person of unsound mind who has not been adjudged by the court as an incompetent person. Remember, a person who is of unsound mind may be adjudged by the court as an incompetent person, but in many cases, okay, a person who is of unsound mind may not be adjudged by the court as an incompetent person. So that this is the person of unsound mind, defector. The person of defector unsound mind, we have to recall that, the law says that if the person of the defector unsound mind enters into a juristic act, when the other party knows that at that time he is of unsound mind, then that juristic act becomes voidable as well. So in this case, the law says that, okay, in the case of a juristic act which has been made by a person of defector unsound mind, okay, then the person of defector unsound mind himself, okay, can just what? Can just avoid that juristic act. Okay, the person of unsound mind who has made a voidable juristic act under section 30, at the time when the mind of such person ceases to be unsound. Okay, so a person who has made a juristic act at the time when his mind was unsound may just exercise the right to avoid that juristic act, provided that, okay, at the time of avoidance, his mind ceases to be unsound. That means that the person of unsound mind may exercise the right to avoid the juristic act only when his mind is sound. His mind ceases to be unsound. That means that his mind now is sound. Okay, because if his mind is still unsound, it's obvious that he will not be in the position to avoid the juristic act. He can just avoid the juristic act only when his mind now ceases to be unsound. Okay, so these are all the persons who are allowed by law to avoid the juristic act. Okay, in the different cases. Okay, one thing which needs to be said finally, it is the heirs. Okay, of course, the law specifies different persons who are allowed by law, okay, to avoid the juristic act, be it the legal representative, be it the minor, be it be it the guardian, be it the incompetent person, be it the curator, be it the quasi incompetent person, okay, and be it the person who has declared an intention on the account of mistake, fraud, or duress, or be it the person of defector unsound mind. What happens, okay, if this person, if the person listed by law dies without exercising the right to avoid the jurisdiction in question, okay, if the person who is permitted by law to make avoidance has not avoided the jurisdiction act, okay, during his life, so when this person dies, doesn't mean that there will not be anybody who is allowed by law to avoid the jurisdiction in question. The answer is no, okay, because the law thinks of the heir. Okay, the law thinks about the heir of this person. Okay, if this person dies without avoiding, then the heir can just avoid the jurisdiction act. This is addressed in the final section, the final paragraph of section 175. Okay, the last paragraph of this section provides as follows: if the person who made a voidable jurisdiction act, if the person who made a voidable jurisdiction act dies before making avoidance thereof, then an heir, of such person may avoid the voidable act. The heir, okay, in Thai. Okay, so that the heir can just exercise the right to avoid the Juristic Act. Okay, so this is something which is addressed, okay, in the case where the person permitted by law to avoid has not done so during his life, so that after his death, the law allow the heir, okay, to exercise the right to avoid the Juristic Act in question, okay. Now, we have seen all the persons who are permitted by law to avoid the Juristic Act, which is voidable. Remember, all the persons in the subsection 1, subsection 2, subsection 3, okay, and 4 of section 175, apart from the persons who are specified by law in section 175, there should not be anyone, okay, allowed by law anymore, okay. Nobody apart from persons specified by law in section 175 can exercise the right to avoid the Juristic Act in question, okay. So if you want to avoid the voidable Juristic Act, you need to make sure that you are one of the persons permitted by law under section 175. If you are not one of those persons, then that means that if you make avoidance, that is not considered by law as avoidance. So when that is not considered by law as avoidance, that will follow that the Juristic Act in question remains valid. Remember, that we have seen the legal consequence of a voidable Juristic Act, that in the case of a voidable Juristic Act, okay, that is unlike the case of a void act. In the case of a void act, it is nullity from the beginning. It is automatic nullity. But in the case of a voidable Juristic Act, okay, it remains valid until it is avoided. So if it is not avoided, the voidable Juristic Act will remain valid. So if it is voided by a person who is not allowed by law, that means that avoidance is not valid. So we have to treat that avoidance as non-existence. So when there is no avoidance, that means that the Juristic Act in question remains valid. Okay, we have seen an example, okay, at least from this case, which is, indeed the Supreme Court decision, okay. This case is concerned with, the avoidance which was made by the person who was not permitted by law. Okay, then we are going to look at this case. It was concerned with a transfer of land. Okay, A just transfer this land to B. Okay, the thing is that when A transferred this land to B, okay, that this land was a personal property. In fact, A was married. You have to know one thing, that if a person is married, then there are two sets of property. The first set of property is called the personal property, okay, or in Thai สินส่วนตัว the property which let's say that you are married before you marry, okay, before your marriage, if you have had any property before your marriage, then that property will be your personal property, สินส่วนตัว but if you acquire any property after your marriage, let's say that when you just register your marriage, then after you register your marriage, you are considered by law as legally married. Since then, if you acquire any property, okay, then that property will be considered by law as common property or สินสมรส So, but in this case, the lady, okay, A was in this case a lady, a married woman, okay. So she had personal property and she transferred this personal property to B. But the thing is that this contract, this transfer, okay, was made by fraud, so that this juristic act between A and B became voidable. You know that. So when you know that when this juristic act became voidable on the ground or on account of fraud, we have seen from section 175. Remember 175 subsection 3 that the person who is permitted by law to make avoidance is the person who has declared an intention on account of fraud. So in this case, when this transfer was made by fraud, then it must be A herself who would have to exercise the right to avoid this transfer. It must be A herself who would have to exercise the right to avoid this juristic act. But A did not do so. On the fact, the one who avoided this transfer was A's husband. The husband just authorized a lawyer, to avoid the transfer. So when the avoidance was not made by A, the avoidance was not made by the person who made the juristic act on the ground of fraud, but it was made by A's husband, who was not the person allowed by law. So in this case, avoidance was made by an unauthorized person. Avoidance was made by the person not permitted by law, so we would have to treat this avoidance as non-existent. So when there was no valid avoidance, that means that this transfer was not void, it remains valid until it was avoided. When there was no avoidance, the transfer here, the transfer here was still what? Was still valid, This transfer was still valid according to the rule of law, which says that a voidable act remains valid, until avoided. You see, so that you have to make sure that if you want to avoid a juristic act which is voidable, then you must be one of the persons permitted by law, indeed permitted by section 175, which we have earlier discussed. Now, if you are the person permitted by law to avoid the juristic in question, how can you make avoidance? We will look at a method of avoidance. The law say this. The law provides in section 178 that avoidance or rectification, in fact, this provision of law speaks of the two cases, the case of avoidance and the case of rectification. But at the moment we are talking about the case of avoidance. Avoidance of a voidable act may be made by declaring an intention. Declaring an intention to the other party who is a person of determinate identity. Declaring an intention to the other party who is a person of determinate identity. So obviously, if you want a person permitted by law to avoid the juristic in question, you will have to declare your intention to the other party. So in most cases, the declaration of an intention to the other party, it is made in a clear manner. You may give a notice. You may give a notice of avoidance. Let's say that you just engage a lawyer, to serve a notice on the other party. The notice will just mention that, that there is the conclusion of a contract on the ground of, let's say, fraud. So now, the lawyer, the duly appointed by the party now hereby serve this notice to the other party, declaring that the contract in question, is now avoided. So in this case, it is the notice of avoidance. The notice of avoidance, it is the declaration the declaration of an intention to the other party who is the person of determinate identity. Okay, so that if you just give a notice, or if you just appoint or engage a lawyer to give such notice, that is the declaration of intention to avoid the jurisdiction in question. Okay, but sometimes sometimes even if you just want to sue the other party, a contract may be made between A and B, like this. A is the seller, B is the buyer. Okay, let's suppose that a contract is made by what? A contract is made, let's say that by the contract has been made, let's say by fraud, so that it is voidable. Okay, so when it is voidable, let's suppose that the seller does not want to be bound by this contract anymore. If A gives notice to B saying that this contract is voidable, and now A wants to avoid this contract, of course that is obvious. That is the obvious declaration of an intention, okay, to avoid this contract. But let's suppose that A has not given any notice to B, but A sues B. So when A does bring an action against B, demanding something, let's suppose that A sues B, okay, A sues B, okay, to demand B to just give this car back to A. Remember, when a voidable act is avoided, then there must be what? There must be restitution. Remember, the parties are restored to their original position. So in this case, A sues B, demanding a return of this car to A. So when A sues B, even though A has not given any notice to B saying that he wants to avoid the Juristic Act, he wants to avoid this contract, but the act of bringing an action against B, it is understood as what? As a declaration of an intention to the other party, okay, in order to avoid the Juristic Act. So bringing an action, it is reasonably understood as what? As a declaration of an intention to avoid the Juristic Act in question as well. Okay, so or even when let's say that just now we talk about the case where A sues B. How about the case where B sues A? Let's suppose that we have the situation where A is sued by B. A does not sue B. A does not bring an action against B, but it is B who brings an action against A. Let's suppose that when the A has sold this car to B, and this sale has been made by what? Let's say that this sale has been made on the ground of a mistake. The mistake as to the quality of the property, okay? So in this case, the contract between A and B becomes voidable. Okay, and A does not sue B, but B sues A. So in this case, A is sued by B. Okay, A is sued by B for delivering this car to B. When A refuses to deliver the car to B on the ground that this contract has been made by mistake, so that it is voidable. Okay, so when A does not want to deliver this car to B, B sues A to demand the delivery of this car to B. So when B sues A, okay, A raised a defense in the litigation. Okay, A just raised a defense denying liability. So when somebody is sued and the person who is sued just raises a defense that he is not bound by the jurisdiction in question, okay? Because that jurisdiction is voidable. So raising a defense like this, it is understood as what? As a declaration of an intention to avoid the jurisdiction. Okay, so that is the avoidance which put it into the jurisdiction. Okay, it is the avoidance which makes the juristic act void from the beginning. Okay, so we have an example in that from this case. Okay, we have an example from this case, right? In this case, both A and B they were heirs. Okay, somebody died and both A and B were heirs. So as the heirs, they were entitled to the share, okay, in the estate. Okay, they could have some property from the estate of the deceased person. Okay, so in this case, A and B enter into a compromise agreement for partition of the estate. In Thai we call this one สัญญาประนีประนอมยอมความเพื่อแบ่งมรดก a compromise agreement for partition of the estate. Thai law say that fine, if you are the heirs, then among the heirs can just enter into a compromise agreement, okay, for partitions of the estate. So if such agreement is made, then all the heirs who are parties to this agreement will have to be bound by this agreement. Okay. So in this case, okay, when the A and B enter into a compromise agreement for partition of the estate, okay, B did not allow A to have the share in the estate, so that A sued B, okay, in reliance on this agreement. So when A sued B, B argued, B raised the defense that B was not bound by this agreement, because this agreement was made by what? This agreement was made by the I can't remember here. By what? By fraud. Yes, this agreement was made by fraud, as a result of fraud. Okay. The thing is that Thai laws require a compromise agreement to be supported by what? By written evidence. Okay, and in this case, of course, the written evidence require also the signature of the parties. In this case, B argued that she did not enter signature. Well, Thai law also allow the use of the fingerprint. Thai law allow the use of fingerprint, the affixing of fingerprints in place of signature. If B, maybe in this case B was illiterate, so that she could not sign, but she could just affix. She could just affix her fingerprint. Thai law allowed the affixing of fingerprint supported by two witnesses. So a fingerprint, okay, the fingerprint attested by two witnesses would be equivalent to a signature in Thai law. Okay, so the thing is that in this case, when A sued B, in order to enforce this compromise agreement, B argued that no, she was not bound by this agreement because she did not put her fingerprint. She just affixed her fingerprint by fraud. So that the instrument here, the compromise agreement, which was made between A and B, it was made by fraud. Okay, because somebody just did something for her to just affix her fingerprint without her volition. Okay, so it was made by fraud. So that when it was made by fraud, this agreement would become voidable. So that when it was voidable, if B avoided this agreement would be void from the beginning. In this case, B did not just give any notice to A, but the thing is that B was sued by A. When A sued B, in order to enforce this compromise agreement, B just raised a defense. Okay, B just raised a defense that no, B would not be bound by this agreement. Okay, because this agreement was made by fraud, so that in doing so, in raising the defense like that, it would be understood as what? As a declaration of an intention to avoid the Juristic Act. So that Juristic Act here, a compromise agreement for partition of the estate, was what? It was avoided by B by her act of raising the defense to the litigation commenced by A. Okay, so that when this compromise agreement was avoided by B, it became void ab initio. It became void from the beginning, so that B would not be bound by this agreement. Okay, now we are coming to the last part of this lecture. Okay, ratification. Okay, we have seen that when a juristic act becomes voidable, well, there are choices to be made by the party. The party may first do nothing, just let the juristic act stand. The party may do nothing and just let the juristic act stand. Or the party may elect to avoid the juristic act. Okay, if the party does avoid the juristic act, then the law says that it is deemed to have been void ab initio or from the beginning. But there is also the last choice, ratification. The party may elect to ratify the juristic act. Okay, ratify the juristic act in order to give recognition to that juristic act as valid. It is invalid, it is voidable, but if the person just ratifies it, if the person elects to ratify it, then that is the way to give the permanent recognition of validity of that juristic act. Okay, you may wonder, well, what the difference between ratification and doing nothing? Okay, because let's suppose that we have a contract between A and B, and this contract is voidable. Okay, let's suppose that A is the one who is injured by this contract. The contract between A and B is voidable. In this case, A, the injured party, may just do nothing. He may just, elects not to avoid the juristic act. So if A just does nothing like this, well, the contract between A and B will remains valid until it is voided. So what's the point of ratifying it? If A can just do nothing like this, when A just does nothing, that means that this contract between A and B will remain valid because there is no avoidance. Right? Why do A have to ratify the juristic act? Well, A does not need to do so, but A can choose to ratify this contract between A and B. Why so? Because even though A can just do nothing, but doing nothing will give sort of uncertainty. Why so? It is uncertainty because B will be in worry. B will be in maybe a big worry. B may be worried as to whether or not A will let avoid the contract between A and B. So if A does nothing like this without ratification, B may still be put in a worry. Of the worry of the subsequent avoidance by A. So in this case, in order to get rid of this worry, in order to arrive at certainty, in order to arrive at some certainty, then A, the party who is aggrieved by this juristic act, may elect to ratify the juristic act. So that in the case of ratification, that juristic act will be regarded by law as permanently valid. Okay, this is the consequence in section 177. If you look at 177, it provides as follows: if any person who is entitled to avoid a voidable act under section 175 has given ratification thereto, it shall be deemed that such act here means such juristic act, okay? It shall be deemed that such act has been valid ab initio. So, the legal consequence of ratification is to give permanent validity, because the law say that once the voidable juristic act is ratified, it will be deemed as valid ab initio. Okay, so it will promote what? It will promote certainty. So B will not be in any worry. Once A just ratify the contract between A and B, the worry on the part of B is removed, because once A ratify this contract, then this contract will be treated by section 177 as valid ab initio from the beginning. See, so this is the nature and the consequence of ratification. Okay, now, right now then we are going to look at the protection of the third persons. Of course, when a juristic act which is voidable is ratified, it may have some effects on third parties. Will the law protect third parties in the case of ratification? The answer is in the affirmative. Okay, we have seen that if we look at the case of avoidance, remember, if a juristic act is avoided, the law also protects the rights of the third parties. Okay, we have seen that in the case of avoidance, the law protects the third party. Let's suppose that if we have a contract between A and B, the contract between A and B is voidable, and later the contract between A and B is voided, the property which is delivered under the contract between A and B, okay, may be in the hands of the third party. Let's suppose that before avoidance, B, the one who has received the property under the contract between A and B, okay, B does sold this property to C, and the law protects C's right. If the contract between A and B is avoided, okay, it may have some effects on the third party. Remember, so that the law says that the third parties is protected if the third parties has received the property for venture, and if the third party has acted in good faith. This is the case of avoidance, remember. And we have also seen that in the case of avoidance, okay, in the case of a juristic act which is procured by fraud, the law even protects the third party even better than other cases. In the case where, let's suppose that we have made a contract between A and B, and this contract between A and B, it has been procured by fraud, and the contract is voidable. If this contract is voided, then the law protects the third party when the third party acted in good faith, irrespective of whether or not the third party has provided, whether or not the third party, that has received this property for venture or not. Okay, this is the case of the protection of the third parties in the case of avoidance. Now, how about, the protection of the third party in the case of ratification? If we have a juristic act between A and B, and this juristic act between A and B is voidable, if this juristic act is ratified, not avoided, but ratified, okay, will a third party be protected by law? The answer is yes, the third party is also protected by law, okay, because the law foresees that if the jurisdiction in question is ratified, there may be, the rights of the third party, okay, being affected, okay, by the ratification, so that the law protects the rights of the third party. The provision of law, it is section 177. According to section 177 here, it provides as follows: if any person who is entitled to avoid a voidable act under section 175 has given ratification thereto, it shall be deemed that such act has been valid ab initio. This is what we have seen, okay? If we look at the ending part of this section 177, it says without prejudice to rights of third persons. That means that any ratification will not have any effect. Any ratification will not have any negative effect on rights of third persons. Okay, we are going to look at this example. Let's suppose that we have a sale agreement between A and B. A, as a minor, at the time when he made a contract with B, A was a minor. A sold his property to B without getting consent from his parents. So when a minor enters into a juristic act without getting consent from his legal representative, the juristic act in question became voidable. Correct? Okay, let's suppose that when this sale is voidable, just 1 week later, 1 week later, A, he has attained the age of 20, so that he has become sui juris. So now, as a person who has full capacity, A just gave this property, the same property, let's say a car, okay, to C. At first, when A was a minor, he sold the car to B, but when he attained the age of 20, he just sold the same car to C. Sorry, not sold. He just gave the same car to C. In this case, after he sold the car to C, just the next day, on the following day, A just ratified the contract between A and B here. So the contract between A and B, which is voidable, is now ratified by A. We have ratification of the juristic act between A and B. So even though A ratifies the juristic act between A and B, this ratification does not prejudice the rights of C, who is the third person. Okay, so in this case, this ratification does not affect C's right. C is protected by law. C is protected by section 177 because 177 says that ratification does not have any prejudice to the rights of third persons. Okay, we can see that the protection of the third persons under section 177 has no condition. Okay, in the case of the protection of the third persons, okay, against negative effects following from avoidance, we can see that the law sets for the condition as to receiving the property for value and in good faith. Okay, but in the case of ratification, the protection of the rights of the third parties, okay, in the case of ratification, is subject to no condition. The third person's rights will be protected irrespective of whether or not the third person has received the property for value or in good faith. Okay, so in this case, even though A, after he when A gave this property to C and later A ratified this contract between A and B, this ratification, the ratification of the contract between A and B, does not have any effect on C's rights. So C does not need to return the car to A. Okay? oh, sorry, to B, because B is a buyer. Okay, so the fact that A has ratified the contract between A and B, okay, does not have any effects on C's rights. So C does not need to return the car to B. So B does not have this car because the law protects C. In this case, B can have recourse against A because if B buy this car from A, B expects to have the car when after the sale, B does not have the car, B suffered the so-called eviction. Or in time we call this one การร้อนสิทธิ์ so that B can just have the recourse against A on the ground of eviction. Okay, this is the provision of law, the provision of sale law. Okay, you can say, I mean, that this provision of the provision on eviction in the sale law. Okay, in the civil and commercial code. Now right, who is entitled by law to ratify? Okay, the answer is that we have seen that in the case of avoidance, the law specifies persons who are entitled by law to avoid the Juristic Act. Okay, so in the case of ratification, the persons who are entitled by law to ratify are the same person who are entitled to avoid the Juristic Act. Okay, this is said in section 177. 177 say that if any person who is entitled to avoid a Voidable Act under section 175, he has given ratification thereto, it shall be deemed that such act has been valid ab initio. So the person who can ratify, it is the same person as the one who is entitled by law to avoid the Voidable Juristic Act. So we have look at the persons who are allowed by law to avoid the Voidable Juristic Act. So that our explanations on that point will also apply to the issue concerning the persons allowed by law to ratify a Voidable Juristic Act as well. Okay, how about the method of ratification? Well, the same thing as the case of avoidance. The law provides this in section 178. Remember, 178 talks about the case of avoidance and ratification. Okay, avoidance or ratification of a Voidable Act may be made by declaring an intention to the other party who is a person of determinate identity, so that if you want to ratify a Juristic Act which is voidable, you need to just declare your intention, okay, to the other party who is a person of determinate identity. Okay, now, okay, there are some rules with respect to ratification. Okay, how about the term? The term for ratification. Okay, the law say that when a Juristic Act is voidable, if the person allowed by law to ratify wants to ratify the Juristic Act in question, okay, he has to do so after the cessation of the factor triggering voidability, after the factor which trigger voidability ceases to exist. So let's suppose that we have a contract. Okay, if we talk about the term for ratification, when can we ratify the Juristic Act which is voidable? We will have to ratify it within what term? The answer is after the cessation of the factor which trigger voidability. Okay, a Juristic Act may be voidable on many grounds. Let's say on the ground of fraud, on the ground of duress, on the ground of mistake. Let's have a look at the ground. Let's have a look at the case of fraud. Okay, so A and B. Let's suppose that A and B, they have made a contract on the ground of fraud. A has told a lie to B So B believe in the lie told by A, and B enter into the contract with A. In this case, the contract between A and B is made by fraud. So the factor which trigger voidability is what? Is the fraud. In the case, is a case of fraud. So when this fraud ceases to exist, at the end of the lie told by A to B, of course, that fraud ceases to exist, and obviously, okay, the fraud even more obviously, the ceases to exist when B know the truth. From then on, B can just rectify the contract between A and B, because the law says that rectification can be made only after the cessation of the factor triggering voidability. In this case, the factor which triggers voidability is a fraud. So when this fraud ceases to exist, okay, in particular when B knows the truth, then okay, B is allowed by law to just rectify this contract. Okay, so with respect to the term for rectification, the answer to the question at what time or the when the party is entitled by law to rectify, the answer is the party entitled by law can rectify after the cessation of the factor which triggers voidability. Okay? Now, with respect to these four persons, if we deal with a juristic act which is voidable, okay, the involving these four persons, three persons, 1, 2, 3. If we have a case which is concerned with these three persons, then if we want to rectify the juristic act in question, okay, we have also to follow the conditions set by law. The three persons are first and incompetent person, okay. The second one is a quasi-incompetent person, okay. The third one is the person of defective unsound mind who has made a juristic act when his mind is unsound, okay. So the condition for these three persons are listed in the paragraph 2 of section 179. Just now when I talk about the term for rectification, that is the rule in section 179, paragraph 1, which provides as follows: rectification of a voidable act is valid only when it is made after cessation of the factor triggering voidability. Now, coming to the three persons here, remember 1, 2, 3. The first one is an incompetent person, okay? The second one is a quasi-incompetent person, and the third one, it is a person of defective unsound mind. If the juristic act which is concerned with this person, okay, needs to be rectified, the law sets the conditions. Okay, if we look at paragraph 2 of section 179, we will see this. The person adjudged by the court as an incompetent person or a quasi-incompetent person, okay, or a person of unsound mind who has made a voidable act, okay, under section 30 may rectify a voidable act only upon knowledge of such voidable act after such person ceases to be as an incompetent person or a quasi-incompetent person, or at the time when such person's mind is not unsound. Meaning what? Meaning that in these three cases, the first case is the case of an incompetent person, okay? Incompetent person. The second case is the case of a quasi-incompetent person, and the third one is the case of the person of the defective unsound mind. If the juristic act in question is voidable, the rectification can be made on these conditions. the first condition is that, okay, if we talk about the case of an incompetent person and the case of a quasi-incompetent person, okay, ratification can be made when an incompetent person or a quasi-incompetent person has acquired knowledge, the knowledge of the Voidable Act, and when that person also recover his capacity. That means that if he is an competent person, okay, he needs to recover his capacity by ceasing to be that incompetent person, okay, when when the court has issued an order revoking the former order and judging him as an incompetent person, okay. So if the incompetent person wants to ratify the Juristic Act, he needs to know about the Voidable Act, and he has to recover his capacity first. Similarly, in the case of a quasi-incompetent person, if he wants to ratify the Juristic Act, okay, he has to know about that Voidable Act, and he has to recover his capacity. He needs to do what? He needs to cease to become a quasi-incompetent person first by what? By an order of the court revoking the previous order and judging him as a quasi-incompetent person, okay? Now, with respect to a person of de facto unsound mind, that means that it is a case of a person of unsound mind who has not been adjudged by the court as an incompetent person, okay? In that case, the person of de facto unsound mind has made a Juristic Act when his mind was unsound, so that the law says that in that case, okay, the Juristic Act in question is voidable, when the other party knows about that unsound mind as well, right? So in this case, if that person of defective unsound mind wants to ratify, the condition set by law is that first, he needs to acquire the knowledge of the Voidable Act. And secondly, he has to resume his sound mind. His unsound mind ceases to exist. His mind ceases to be unsound. That means that his mind is now back to normal. He resumed his sound mind, okay? If he has not yet resumed his sound mind, the law does not allow him to ratify, okay? So back to, section 179, paragraph 2. Remember, 179, paragraph 2 talk about ratification by these three persons, okay? Ratification by these three persons, okay? And in competent person, a quasi-incompetent person, and a person of de facto unsound mind, okay? In these three cases, ratification will have to be made, okay? On the conditions set by law, okay? We have addressed all these conditions, okay? So now, coming back to 179, if you look at 179 in the last paragraph, it says that the provisions of paragraph 1 and paragraph 2, the provision of paragraph 1 and paragraph 2, which we have discussed a while ago, okay, shall not apply if ratification of a Voidable Act is given by legal representatives, the guardian or the curator. That means that the last paragraph deals with ratification made by what? Ratification made by the person who look after the person who have no capacity or who have restricted capacity, okay? In the case of a minor, remember, then, okay, ratification can be made by whom? Ratification can be made by, remember, by the legal representative. In the case of an incompetent person, Rectification can be made by the guardian, and in the case of a quasi incompetent person, rectification can also be made by whom? By the curator. In this case, if the legal representative or the guardian or the curator, okay, gives rectification, then this person, okay, the legal representative, the guardian or the curator, okay, does not need to observe the conditions set by law in paragraph 2. That means that, okay, if this person, the legal representatives of a minor, the guardian of an incompetent person, or, okay, the curator, okay, of a quasi in the competent person want to rectify the Juristic Act, he can do so without having to follow the rules in paragraph 1 or in paragraph 2, okay? So he can do so immediately, okay, without having to wait for the factor triggering voidability to have terminated, and without having to wait for the minor or the incompetent person or the quasi-incompetent person, okay, has the knowledge of the Voidable Act or regain, the capacity. Okay, so in this case, if this person, the legal representative, the guardian or the curator ratifies the Voidable Juristic Act, that person may do so, immediately without having to observe, any conditions set by the section 1.79 in paragraph 1 or paragraph 2 at all. Okay, so this is something which you have to bear in mind. Now, we are coming to the final part. Okay, just now, if we get back to what is said, in the section 177, remember, 178. 178 say that rectification can be made by what? By declaring an intention to the other party who is a person of determinate identity. So, if you just, give a notice to the other party, telling the other party that you want to ratify the contract, then it's fine, because that is an obvious declaration of an intention to ratify the Juristic Act. But sometimes, even though you have not done, if you do not carry out any action, obviously understood as giving ratification, okay, but it can be presumed to be ratification, okay. In this case, the law also, talk about the implied ratification, okay. It is not the obvious one, but some conduct, some circumstances can be understood as the act of ratification, okay, by way of implication, okay. The implied ratification is embodied in section 180 of the Civil and Commercial Code, okay, which provides as follows. After the term, oh my God, it's now 1 hour 30 minutes, okay. So the lecture today lasts for more than 3 hours. Remember, we have part 1, part 2, and part 3. The lecture today consists of 3 parts. Part 1, part 2, and part 3. This part is part 3. We have part 1, okay. The lecture in part 1, okay, the lasts for about an hour. In fact, 1 hour, something, okay. The lecture in part 2 lasts for about an hour as well. The lecture in part 3 now lasts for 1.5 hours. So in total, we have the lecture for more than 3 hours. More than 3.5 hours this morning, okay. So I think that you have obtained a lot of benefit, okay, but I am very, very tired, okay. Back to 180 of the CCC. After the term allowed for ratification under section 179, if they occurs by an act of the person entitled to avoid the Voidable Act under Section 175, any of the following circumstances in relation to the Voidable Act, it shall be deemed to be ratification unless reservation is expressly made in any manner. Again, I try to just read the important part, okay? Skipping some parts which is not relevant, okay? After the time allowed for ratification, okay, if there occur any of the following circumstances in relation to the Voidable Act, it shall be deemed to be ratification. That means that even though it is not the obvious ratification, okay, but the circumstances in question, okay, can be presumed to be the act of ratification, okay. What are the circumstances? What are the circumstances which can be presumed as the ratification, okay? This or this. These circumstances are listed by Section 180 in paragraph 1, okay, in the 1, 2, 3, 4, 5, 6. Look at 1, 2, 3, 4, 5, 6 here. The first one is performance of obligation. The performance of the obligation has been made in whole or in part. Let's suppose that we have a contract between A and B, and this contract between A and B is voidable. Okay, let's say that this is a contract for the sale of a car. Right? So, let's suppose that this contract has been procured by fraud. So that it is voidable. Okay, even though A has not given a letter to B, even though A has not given a notice to B, saying that he does want to ratify this contract, but he demands payment of the price by B. So when A demands payment from B, okay, this is performance of the obligation. Let's say that A demands payment from B and B has paid the price to A. So when B paid the price to A, this is the price, okay? The payment of its price is the performance of the obligation. When performance of the obligation has been made in whole or in part, this is the implied ratification. How about the second one here? Performance of the obligation has been demanded. If A demands B to pay the price, the demand by A for the price here, it is the act of ratification, okay? It is the implied ratification under Section 180 as well. Or number 3 here, novation of the obligation has been carried out. You have not studied the law of obligation yet. Novation, okay, that is turning the current obligation into something else, okay? In time we call this one blank nihai. Okay, if there is any novation of the obligation, of course, back to this contract, the contract between A and B, this is a contract of sale, so that both parties have obligations. A has the obligation to deliver the car to B, B has the obligation to pay the price to A. Let's suppose that the parties want to make the novation. Let's say that the party make the agreement saying that, well, now, the delivery of this car is changed into the delivery of a big motorcycle. This is the novation, okay? So if there is the novation, okay, being carried out by any party, let's say by A, this is understood as an implied ratification as well, okay? Or number 4, security has been given for the obligation in question. Let's suppose that B does not have money to pay for the price, and B here, okay, give his ring as security for payment. So if B give the ring as security for payment, okay, in this case, B ratify this contract. B can no longer claim later that this contract is voidable on the ground of fraud, on the ground of something. Okay, thus the next one, a transfer of rights or liability has been made in whole or in part. Let's suppose that, okay, A transfer his right to receive the price from B to C when A is entitled to, to get the price from B, but A transfer that right, the right to receive payment from B to C. Okay, A may just mean that transfer this right to somebody else. The transfer of this right by A will be understood as what? As the implied ratification of this contract between A and B. The last one, any other act perceivably indicative of ratification, okay, has been carried out, even though there is an act which does not fall under 1, 2, 3, 4, 5, but it is something similar to 1, 2, 3, 4, 5 here. Okay, so it is any other act, okay, which is perceivably indicative of ratification. That is understood also as the implied ratification. Okay, so even though it is not the express ratification, it is the implied ratification. So that the juristic act which is voidable, when it is ratified, will be deemed to have been valid from the beginning, remember. Okay, that's it for today. Okay, so the lecture today seemed to be very, very long. Okay, we discussed, the legal consequences of a voidable act. Okay, we have seen so many the consequences, okay, in the case where a juristic act becomes voidable. Okay, I hope that you have proper understanding of the lecture this morning. Okay, so thank you very much for your attention. Okay, and I see you next week. Thank you. Good day.